against a reporter anchor named Shuddhoshil of Priyobandhu Bangla Media uploaded and circulated an offensive video against
Wrong statement made.
How many documents?
135(2) notice
Milord,
was
huh?
issued.
How many documents did you
Lordship
seek
is
from this
being-
person?
Malad, I am coming. 16.
Lordship,
You will produce
35(2)
all relevant
notice was
documents.
issued.
Malad, I am coming.
I expect the submission.
Please
should
don't
be fair,
interrupt me
Lordship.
in this way. This is not the way to
But that
address
is
the
not the
court.
way to misguide the bench. Please
Anyway,
say
please
that 35(2) notice was issued.
Mr. Chatterjee, we
Lordship.
will not decide this case ex parte. If we at all decide, we'll
Lordship.
hear you,
My lord,
point out,
that-
you point
that
out whatever erroneous submission is made on behalf of the appellant. As it is very difficult to hear you virtually. You are not very clear.
Because I know the constraint of time. I will try to cut short the matter, which is very much important, relevant. I will refer that only. But actually, this is a case. There is a lot of circulation and publication on the YouTube channel.
Why don't we first see the order as we...
I am just referring to why this case.
Yes.
This in the said YouTube channel, there is a video which has been published and circulated, which is very derogatory and malicious and tarnishing the Honorable Chief Justice of India. There was a video. In that scope, FIR has been lodged. Now, kindly see the first. I will take up the what is the contents of the FIR, then the court below the order. In the MAT application, sorry, can 1, Can 1, at page 15. Can 1.
Yes.
Kindly see the FIR is on 13/9/2024. Kindly mark the date, kindly. Then the sections are 267, 352, 353, 1B, C, subclause 2 of the BNS. I will read later on the what is the corresponding section of the IP. For the moment, I am not.
Intervene for a moment.
Contents, next page 16.
Lordship, may intervene
No,
for a
16,
moment.
1, 6,
That is of can 1.
Lordship,
Yes, Lord.
Lordship, am I audible, Lordship?
Can
Yes, you are.
Only thing is that may I intervene for a moment. Lordship, may kindly see the order once.
I will.
That
Of
will
course.
apprise the Lordship.
Yes.
Yes, I such and such then address. This written complaint against a reporter anchor named Shuddhoshil of Priyobandhu Bangla Media uploaded and circulated an offensive video against the Honorable Chief Justice of India in pertinence to the matter of RG Court, which the Supreme Court took suo motu cognizance of the matter. The reporter anchor has mentioned above prepared a report and circulated the contents through communicable devices that are very much offensive, defamatory, and menacing in character. The manner in which the reporter addressed the Honorable Chief Justice of India is very disrespectful, and the full content of the said news report circulated by the reporter is false and caused annoyance, inconvenience, insult, injury, and criminal intimidation. Whereas the reporter anchor intentionally made the false report by distorting the original fact and misrepresenting the false information to create enmity and hatred toward the society. Not only that, the media with malafide intention circulated the news report challenging the power of the Honorable Chief Justice and also in imaginary way threatened the public to agitate against the Honorable Chief CJI solely. That the said circulation report where the reporter anchor alleged that the Honorable Chief Justice of India is not performing his constitutional obligations by delaying the process of justice to the public of nation. It was also alleged by the reporter that the Honorable Chief Justice is working as per his own hidden agenda and the CJI is intentionally lingering some cases, legal issues according to his own sweet will without considering the gravity of the cases and law of the land. That the reporter even alleged that CJI is acting biasly in some selective issues, thus by circulating the said video, the anchor intentionally, next page below, insulted the CJI of the country and the entire judicial system of the nation by provoking the public at large, which shall break the public peace and tranquility and created feeling of hatred, enmity, and doubt among the minds of the people of this nation. That the reporter anchor had stated in the report that the Honorable Chief Justice of India is the most tarnished CGI ever in our judicial history, and the Honorable Chief Justice shall immediately be impeached from the chair. That the reporter also stated that the hearing of the matter RG Kar will not be listed before the Honorable Supreme Court, and RG Kar will not get justice until the Honorable Chief Justice is impeached from the acting CGI. That the entire report news is fake, which was circulated on social media to intentionally defame the Honorable. This was the content that was published in his own the YouTube channel. It has been circulated. There are lakhs and millions of people as the viewers. This video has been circulated on 2nd September. RG Kar incident took place on 13th August 2024. 9th August. 13th August. Anyway, my lord, what is the date? 2nd September, this video has been circulated, uploaded. 13th September, this affair has been lost. Just after 10-11 days.
After how many days this affair was?
10-11 days.
In 11 days.
Yes. 13th September, this affair has been lost.
Yes,
2nd September, this uploaded.
that is published.
Yes. And kindly recall, my lord, in entire state, even across the country, even there was this my lord, anarchy with regards to this RG Kar situation.
Admitted.
Now, my lord, the now, my lord, kindly now come to the sections. My lord, what might it is troubling me and why I am agreed by. This is the reason I am coming. I am letting cut shorting the matter. My lord. 267, 352 remain as to 267, 352, 353 subclause 1 B C 2.
যাও না বিএনএস টা
My lord,
ওটা কি এটা সিআরপিসি টা মনে যাও বিএন এই
ভারতীয় ন্যায় সংহিতা এই না না ন্যায় সংহিতা
এসিটা কিন্তু বন্ধ করা যাবে?
এইটা
এসিটা একদম নিচে লাগছে বা উইংসটা একটু উপরে তুলে দেওয়া যায়।
Yes.
Yes, my lord. Section is 267, 352, 353, 1BC2. My lord, first I will read 352. 267 I'll come later.
252,
352, my lord.
352.
কি ছিল এটা বাবা ভারতীয় ন্যায় সংহিতা তো
My lord. I hand over my book, my lord.
yes I think so
But it is marked, my lord. I'll kindly be excused, my lord.
352 পাওয়া গেছে দেখতে তো চলে আসছে 347
আমার
তোমার কি এই বইটা কোনটা দেখছো
একই তো ন্যায় সংহিতা আপনি 353
Tell that, Lordship, this matter, Lordship, can be cut short. An argument could be advanced by citing the order itself, why the order was stayed,
ঠিক আছে
why the FIR was stayed.
Oh, 151.
yes
lordship got it.
Does that
We are not
disclose
well versed
any
on
of the
this news,
computable offense?
the amendment.
It will take some time.
Yes, yeah, even it's to some extent difficult, my lord. 352, my lord. Lordship got it.
Yes.
Now, intentional insult with intent to provoke breach of peace. That was the, my lord, the heading. Whoever intentionally insults in any manner and thereby gives provocation to any person, intending or knowing it to be likely that such provocation will cause him to break the public peace or to commit any other offense, shall be punished with such and such. May I be very candid? This is a non-cognizable, my lord, and the non-bailable. 352.
non-billable
Non-bailable, non-cognizable. Now, 353. 353, my lord, the sections which has been added, 353 subclause 1, B, C, and 2. This has been section added. Now, 353 kindly come. Statements conducting to public mischief. 1. Whoever makes, publishes, or circulates any statement, false information, rumor or report, including through electronic means. So 353 subclause 1 my lord, well attracted. My lord, then B and C. Next page. With intent to cause or which is likely to cause fear or alarm to the public or to any section of the public whereby any person may be induced to commit an offense against the state or against the public tranquility. And C, my lord, with intent to incite or which is likely to incite any class or community of persons to commit any offense against any other class or community. This section my lord, non-bailable and also my lord, cognizable. Kindly mark the cognizable. And 353 subclause 2, whoever makes, publishes and circulates any statement or report containing false information, rumor or alarming news, including through electronic means with intent to create or promote or which is likely to create or promote on grounds of religion, race, place of birth, residence, language, cluster, community or any other ground whatsoever, feelings of enmity, hatred or ill will between different religions. This is also my lord, the non-bailable and cognizable. Now, my lord, kindly examine the 267 section. Who 67, Lordship? Lordship got it? Yes. 267 is, my lord, intentional insult or interpretation to public servants sitting in judicial proceeding. Whoever intentionally offers any insult, causes interruption to any public servant, while such public servant is sitting in any stage of a judicial proceeding, shall be punished with simple imprisonment for a term which may extend to such and such, my lord. This is also, my lord, non-cognizable and bailable offense. So, my lord, here, out of the 3 sections, 2 are non-bailable, 2 are cognizable, 1 is non-cognizable offense. My lord, in section, which is, my lord, in CRPC, in BNS 174 section said, BNS is 174 subclause 4 says, where a case, what I am reading, and where a case relates to 2 or more offenses of which at least 1 is cognizable, at least 1, the case shall be deemed to be a cognizable case, notwithstanding that the other offenses are non-cognizable. So, my lord, here, by the affair of 13/9/2024 discloses the cognizable offenses. Discloses the cognizable offense. The moment on 13th September they disclosed the cognizable offense, police had registered this affair, my lord, under these sections. Because, my lord, it is the duty of the police, it is the law of the land. The moment the cognizable cases has been disclosed, immediately has to be registered. An investigation to be carried out in terms of the procedure, my lord. So, police had done this, and then in consequence, they had to, my lord, issued a notice for his appearance to substantiate and to produce some documents. That notice was issued, my lord, on 16/9/2021. I have annexed.
Page 18.
My lord, must be, yes, right, your lord, you are seeing.
This is 13/9.
13/9 asking him to appear on 16/9, my lord. That is, your lordship will find 1, 2, 3, 4, 5, 6 line. You are directed to appear.
Yes.
That's why I said, because I'm skipping, my lord, that 16/9. But in the reply through a mail, he said that I need a more time. And then he sought for a time.
Anyway, documents were sought for from this person.
Exactly. These
How
are the
many documents did you
A,
say?
B, C, D, F.
A, B? No, not A.
you will not commit any offense in
No, no, which document?
Lordship, it's a completely wrong statement made.
How many documents?
135 two notice
Milord,
was
huh?
issued.
How many documents did you seek
Lordship
from
is
this
being-
person?
My lord, I am coming. 16.
Lordship,
You will produce
35
all
two
relevant
notice was
documents.
issued.
My lord, I am coming.
I expect the submission.
Please
should
don't
be fair,
interrupt me
Lordship.
in this way. This is not the
Please.
way to
But this
address
is
the
not the
court.
way to misguide the bench. Please
Anyway,
say
please
that
submit.
35 two notice was issued.
Mr. Chatterjee,
Lordship.
we'll not decide this case ex parte. If we at all decide, we'll
Lordship.
hear you,
My lord,
point out,
that
you point
30
out whatever erroneous submission is made on behalf of the appellant. As it is very difficult to hear you virtually. You are not very clear. The sound quality is not very good. Please don't interrupt. We'll hear you. If we decide the case, obviously we'll hear you.
Now you see, you
My
have
lord,
stated
yes,
that you
kindly-
would produce all
My lord,
relevant documents
Yes,
for
my
the
lord.
purpose
It
of
is
investigation.
for the purpose of, my lord, the
investigation.
investigation, my lord.
So
These are the direction were given, police.
definitely, but actually you see some specific documents.
It
are
was
sought
not,
for.
my lord, because kindly see on 13th we received and then 13th the notice was issued. That's why we will examine, we will carry out the investigation.
Yes,
This is the
yes,
reason.
the person
So,
will appear.
Exactly, my
You
lord.
will
That's-
also
this is not
comply with everything you will do.
This is not a case, my lord. This is not my case.
Documents.
Yes, so notice was issued to him, and then definitely he has sought for a time. Then, my lord, on 29/20/24, my lord, he has filed this writ petition
Yes,
before
which
this honorable
page?
court.
Okay.
On 17th,
Challenging this notice
challenging the
Yes.
notice and FIR.
and FIR.
For quashing. Read file for quashing of the affair and challenging the notice on 17th itself the next day.
And the learned judge has quashed it.
Not
No,
quashed it.
interim,
That
any,
is
what is the interim order
yes.
passed?
Now, my lord, kindly come to the order impugned. My lord, first, before I come to the impugned order, I would like to hand over the in between the order passed by the learned judge, my lord, court below. My lord, may I hand over the two orders? My lord, sorry. My lord, kindly turn out the second my lord, page. That is the order which I have handed now just now. The order dated 25th September 2024, my lord.
Yes.
20th September, my lord, second running page. The very first day, my lord, the police are restrained. Lordship got it, the last from bottom.
Page 25/9, and that is 25/9.
No, my lord.
Order dated.
Order date 25/9.
Yes.
Second page.
Internal page 2,
Page 2.
second last paragraph.
Lordship, page number, Lordship.
The police are restrained from taking any step in
So
response to subject
which page you are referring to?
FAR till 4th October 2024 until further order, whichever is earlier. So, my lord, in the 25th September, so FAR was registered 13th September, notice issued on 13th September, asking him to appear on 16th, 17th he filed a writ petition, 25th there is an order of prohibitory order from the learned court, my lord. Now, my lord, what is the order into? Matt, it has been annexed. Judicial proceeding suo motu taken up by the Honorable Supreme Court in connection with a brutal incident which took place in the RG Kar hospital. Several mass protests and agitations are taking place in the state, country, and even beyond the boundaries of the country from the very next day of the incident. There are various versions of the incident that are doing the rounds. The manner in which the general public has got themselves involved in the mass agitations reflects the views of the public in general and not of an independent individual. Then, my lord, 12. I'm skipping paragraph 11, 12. The court has conversed with the de facto complainant, Otri Sharma, who was present virtually. My lord, in the earlier order, he directed to appear virtually or personally. He disclosed himself to be the legal practitioner and submitted that he was concerned with regard to maintaining the dignity and majesty of the judiciary. Then, my lord, kindly come paragraph 14. The court is not at all convinced how court has arrived. There is no case diary even called for. No daily diary even was produced, nothing. But
Hmm.
court said convinced that there is any likelihood to cause fear or alarm to the public or to any section of the public to commit an offense against the state or against the public tranquility by the act of the petitioner. The right to free speech ought not to be curtailed by putting threat on individual to initiate criminal proceeding. According to the learned judge, FIR lodging is a threat.
Yes. Yes.
15. The instruction forwarded by the inspector in charge Siliguri police station, it has been instruction to me, Milord. In connection with a case number such and such, does not mention whether the public or any section of the public committed or tried to commit any offense in furtherance to the video which was uploaded by the petitioner. Milord, that would be reflected in the CD, case diary, it is a mirror. It was the instruction from the police station, the police personnel, that this is the progress of the investigation, which I have handed over to the Milord, the learned judge. Now, Milord, paragraph 60. As regards the allegation of airing offensive, defamatory, and menacing report against the Honorable Chief Justice of India, the police could not have taken steps in response to such allegation till there is any complaint lodged by either by the Honorable Chief Justice of India upon instruction of the Honorable Chief Justice of India. Milord, with regards to our 267, that is the Honorable Chief Justice of India. If he is being aggrieved, then he can file. But here the section, even Milord, in the Honorable Supreme Court, even in other Milord, the false and the malicious Milord, the video uploaded in the same issue, the cases has been initiated by the Honorable Supreme Court, even at the instance of the Honorable Chief Justice of India. So, Milord, 267, the person being aggrieved, the Honorable Chief Justice, definitely. But section with regards to Milord, the 353 subclause 2, 353 is B,
Yes, what is there, 353?
Milord, which I have read. Milord, I'll
That is the cognizable and non-bailable.
cognizable, non
353.
353.
Yes, 353.
2,
No, 3.
353, 353B,
353B.
1B, 1B.
Yes, so that is cognizable
Yes,
and non-bailable.
yes.
No, here you see, this is an admitted position. There is derogatory remarks upon the Chief Justice, interference in the administration of justice. Definitely, on the face of it is appears. But how far this section is applicable? That is the only question.
353.
Yes, yes.
That is the police to investigate.
No. How
That
far
police will, that is the
From-
court
no,
cannot
from
sitting
that-
over the Milord.
from that allegations?
Kindly
Whether
353
this-
one, again I am reading
Whether
B.
that section is
B.
undoubtedly it's a
Milord,
derogatory
B,
remark.
B, kindly read B. With intent to cause or which is likely to cause fear or alarm to the public or to any section of the public. So, Milord, by way of this circulation, that is a cause of fear or alarm to the public, whereby any person may be induced commit an offense against the state or against the public tranquility. Number 2. C, sorry, with intent to incite or which is likely to incite any class or community or person commit an offense against any other class or community is a provocative. 2. Whoever makes, publishes, circulates any statement, report containing false rumor or alarming news through electronic media. So remember, this is the reason 353 subclause 2 is well attractive.
Where is the other section which you relied?
267 1.
267.
That is upon the person being aggrieved, the Honorable Chief Justice. There are 2-3 sections has been incorporated.
Yes.
One is cognizable, 2 is cognizable, 1 is non-cognizable. I said from this section that if the one section is a cognizable offense, then other would be deemed to be a cognizable. So, Milord, when the cognizable offense has been disclosed, it is the duty incumbent of the police to carry out the investigation. May I read further sections? Now come to the judgment, Milord. Milord Justice Chaudhary.
Yes.
No, Milord.
FIRs are registered, that FIRs are challenged, that it does
Always.
not disclose the offense, or
Always.
whatever it is.
Always. They challenged it. Now the question is
Yes.
under the judicial scrutiny,
Yes, whether
Whether
it's 26 or any other revision.
whether the investigation police, if the court can stall the investigation at the very nascent stage. This is my challenge.
Yes.
This
Yes,
is 2021 Supreme Court. When a prayer for quashing affair is made by the alleged accused and the court, when it is exercised power 482, only has to consider whether the allegation in the affair disclose commission of a cognizable offense or not. The court is not required to consider on merits whether or not merits of the allegation make out a cognizable offense, and the court has to permit the investigating agency police to investigate the allegation in the affair. Then, my lord, last paragraph 33.16. The aforesaid parameters would be the applicable and the aforesaid aspects are required to be considered by the High Court while passing an interim order in quashing petition excess of power 482 or 226. However, an interim order or stay of investigation during the pendency of the quashing petition can be passed with circumspection. I
Mr.
understand.
Chaudhary, without hearing Mr. Chatterjee,
No,
we
that
cannot pass any
definitely
order.
that cannot be allowed.
Yes. So therefore, what to do? Interesting matter. I have at least.
Can I argue before your lordship there in Calcutta?
No, then we'll have to make it part heard.
Well, because already a substantial part I have completed. 90% I have finished.
You have finished. He has not even
There
started.
is on hardened parts.
He has not even started. Mr. Chatterjee has not even started.
Otherwise, my lord, the court's time would have been, it has been.
No, we enjoyed listening
my
to
lord,
you.
that would be for academic purposes.
This
No
is
court would-
I
interesting,
learned
very
about this
interesting.
case. This is very helpful.
Very, very interesting case even.
Very
Very
interesting.
interesting.
This
Nyadika.
three-judge judgment.
So, my lord, kindly make it part hard. I will, my lord, otherwise, my lord,
No, Mr. Chaudhary, the higher authorities frown upon that. I'm telling you. And we have to face the music. You understand when I say higher authorities?
I got it. But an administrative authority higher.
So-
No one is higher than
Yeah.
in judicial proceeding,
No.
my lord. Here in the state of Bengal.
We can't pass any.
Well, 15 minutes can be spared tomorrow. Definitely subject to.
No,
I
but
cannot
then only hearing you will not serve the
then
purpose.
Deserve the judgment, my lord. But otherwise,
No, Mr. Chatterjee,
No, Miller,
will you
tomorrow-
finish in 15 minutes?
tomorrow, my lord.
Lordship, it is difficult. To a certain extent, it is difficult, Lordship, because there are, I will be arguing on the what point I am telling you, Lordship. Mr. Chaudhary has already referred to the sections of this Nyaya Samhita. I will be referring to the sections from the Nagarik Suraksha Samhita, which clearly gives some impediment upon the police regarding the offences committed against the judiciary or judicial officers. There is a clear embargo that police cannot, magistrate cannot take cognizance on that.
Sorry,
So there
let
is
us record an
conflict on
order.
that.
We had,
My lord, I have discussed my all.
sorry,
My
And
lord,
Lordship, that if
protected
Mr.
by an interim way, because the report we have to file by 22nd 11.
affidavit.
Affidavit disclosing. My lord, may I very candidly I will submit. I will not arrest him. Allow me to cause an investigation, and I will submit the report.
No,
I will not
that,
arrest him. No coercive step with regards to any arrest. I will not. I am giving an undertaking. But permit me, because no court can snatch my power.
Lordship, the
It's
question
my
is,
statutory
Lordship,
power.
that's
we may
That's
well
where
agree
Lordship
with
has to
you.
show.
Again, without hearing him, can we
That
pass
is
such
Then
an
below
order?
22nd I have to file. Otherwise,
No,
I may face
that we are thinking what we
That-
can do.
that kindly protect me in that score.
Lekho. Today is the penultimate day of this circuit. Stop. Tomorrow, only criminal matters will be taken up. That too, in the first half, as in the second half, both of us propose to sit singly. Stop. Paragraph. With the ardent hope that hearing would be concluded, we had taken up this appeal for hearing. Stop. It is 4:40 now, 4:40 p.m. now. Stop. You have concluded? No, some
Why I have concluded.
Mr.
My lord, if it is making up reply, if any, that I will make a reply.
Mr.
Law part.
Chaudhary, learned AAG has just about been able to conclude his opening submission.
Yeah.
Stop. We have not heard Mr. Chatterjee, learned counsel appearing for the respondent oblique writ petitioner. Stop. Hence, we are not in a position to pass an order of stay of the order impugned as such, even if we are prima facie satisfied that such an order is warranted. Stop. Paragraph. However, Mr. Chaudhary makes a valid point that the affidavit that the learned affidavit or report, what is it?
Affidavit.
Report in the form of affidavit.
No, affidavit.
Okay,
What,
agree.
what prompted us,
Yes, yes.
necessitated us,
That the affidavit that the learned judge has called for from the respondents cannot be filed. No, has made a valid point that no meaningful affidavit disclosing the necessity to proceed with the complaint in question can be filed without making further investigation in the case. Stop. However, further investigation has been stayed by the learned single judge. Stop. That order is under challenge in this appeal. Paragraph. We are not staying the operation of the order impugned, as we have not heard Mr. Chatterjee appearing for the writ petitioner. Stop. However, we prima facie are of the view that without further investigation, no meaningful affidavit can be filed by the respondents in the writ petition. Stop. Hence, the requirement of filing the affidavit, requirement of preparing and circulating the affidavit by November 22, 2024 is kept in abeyance for the time being. Stop. Let this matter, paragraph D, be placed before the next available circuit bench.
till the disposal of the appeal, kept in abeyance till
For the time being, we have said,
Till further orders.
till further order, till for the timing will
timing
do.
is always,
That will do.
that is sufficient.
Mr. Chatterjee, we have no time to hear this. We are not
Yes.
staying the order, but
My lord.
that
That,
portion
that I
only.
am not agreeing, right? That I am not
The
agreeing, right?
judgment
lord,
and cited record shall be retained with the record, I will take back.
You take back. Or you can keep the record now, because we have not recorded the
And
argument.
we have to again open.
my lord,
the-
sorry.
Yes,
Before my lord's
Yes.
rise, my lord, I have just entered the link to tender my apologies, my lord.
no, that's
What
all right.
No, my lord, I'm
That's
extremely
right.
sorry, my lord, my unqualified apology, my lord.
That-
I've
that-
embarrassed the bench, my lord.
That's all right. That's all right. Thank you.
I'm obliged.